And you're telling the court that you've not made a payment until 2025?
No.
You were not saying that, or you are saying that?
I am saying that.
Why was there?
Or if I file a motion to come back.
I can't tell you what you can file, whatever motion.
I'll file a motion and
appropriate.
we'll take care of that another day.
Sure. And we placed both under oath. What's your motion regarding the
I was on my daughter's TikTok and just doing my parental checks, making sure she's not talking to nobody she's not talking to, supposed to be talking to. And they were in the car with alcohol. And our order of divorce states there's not supposed to be any alcohol 8 hours prior to having children. And I printed off a copy, a picture, and I sent it to Mrs. Ms. Schultz, and I also have a copy that I printed off last night at Walmart.
Okay, so you have a photograph with you?
Yes, the court too is from Ms.
Well, I don't
Ms. Schultz, I'm sorry.
That's okay. It is attached. Okay. Well, that's right. It is. Okay. But it's not for the court to consider at this point. Have you seen the photograph, Ms.?
Yes.
Okay, any objection to the court reviewing it?
No.
Okay, sir, we'll take it. We'll have marked as defendants 1. It's in it.
There's 2 photos, one being out black.
One's black and white, one's color. Any problem with both of those? I've not looked at it.
They look like different photos. Your Honor.
Well, which one do you have any objection? Which one do you have an objection to?
I'm just pointing out that they're different photos. You asked if I've seen them and if I would object to them. I've only seen one photo. I've not
Okay,
seen both photos.
I want you to see both. We'll hand them down for you to look at.
Thank you. No, I have no objection, Your Honor.
Okay, thank you. Appreciate that.
Yes.
We'll consider 1A and 1B. Okay. It's admitted. Sir, do you have any idea when this photograph was taken?
It's a TikTok video, so it's a screenshot of the video that's on TikTok.
Okay. Does it indicate on the TikTok app when this was taken, if you know?
Can I go on and look quick?
But
I don't.
That'll refresh your recollection.
Just give me 2 seconds. February 21st, it says. 2/21, it says on that.
February 21st. Okay. And you're offering this, it's admitted that it's a violation of the court order, correct?
Yes.
Anything else?
Yes, I had also was going through my son's phone, and I found pictures of more alcohol. It's just chilling, just sitting in the hallway. And I emailed, and I think Wednesday or Thursday, Ms. Schultz, sorry. I emailed Ms. Schultz Wednesday or Thursday, I think Thursday, yesterday, and let her know. She told me she's bringing it to court today.
Do you have photos of those?
Yes, I have one photo.
Would you like to show that to Ms. House? Please show. Any objection to the court reviewing that photograph? Sir, would you like to present that to the court reporter? That'll be marked as well as plaintiff's chief.
We'll give it to him.
Is there anything else you wish to present on this issue?
No, Your Honor.
Ms. House, your response, please.
My response is I don't know when or where this photo was taken, nor am I consuming any alcohol in the picture/video. I'm not even in the photo. Further, based on what he was just saying, There's really no way to know when a photo was taken, only when it's posted. But I didn't realize the date in question. He just reported that it was taken on February 21st, which was during his parenting time, actually. Again, I don't know, I'm not consuming alcohol in the picture video. I did read through the motion as it was presented with the email exchange from Mr. Pomeranke and Michelle, stating that she had reviewed it and did not see an indicated of alleged order violation because the JOD provision is that under neither party consume alcohol.
This courtroom hearing exploded when a father claimed he found proof on his daughter's TikTok that alcohol was around the children, violating a court order. He brought screenshots to court, believing he had caught the other parent breaking the rules. But the mother pushed back, arguing there was no proof of when the video was taken, she wasn't shown drinking, and the date may have actually been during the father's parenting time. What started as a shocking accusation quickly turned into a heated fight over the evidence. What do you think, real proof or a misunderstanding? Comment below, and don't forget to like and subscribe The Legal Lens for more courtroom drama.
During parenting time, again, I'm not consuming any alcohol during parenting time. This is not proof of that. As far as the second picture that he just sent now, saying that it was from my son that took that photo, I don't know when or where this photo was taken. Well, I know where it was taken. That one is in my hallway. I don't know when it was taken. Brendan comes and goes all the time, and it could have been on my own personal time. However, that's still not my alcohol, but and still not proof of me consuming alcohol. I guess that's really what I have to say about it.
Okay, thank you. Any rebuttal arguments, sir?
No, just one thing, Your Honor. It was actually posted 17th. I'm sorry. Which would have been her parenting time, and it's her vehicle. I don't own a vehicle.
Okay. Any other rebuttals?
No, alcohol has been an issue with her. I'm going on 5 years this November, this August, and 1 year or 2 years, no smoking cigarettes. November.
What page is the judgment, the prohibition? I'm trying to find it.
This is the first issue.
Our written opinion and judgment, of course, isn't numbered, Your Honor, but it would be page 7, approximate, the second paragraph above communication.
Well, I'm looking at the child support order. When was that judgment entered?
July 18th, 20. And the provision at issue, Your Honor, is that neither party shall consume any controlled substance except as may be prescribed, nor shall either party consume alcohol 8 hours prior to or in during any subsequent.
Okay. All right, the court has received evidence in the court, in the record, specifically regarding alcohol reportedly possessed by the plaintiff in this matter, one of which appears to be in a motor vehicle because I see a seatbelt, and clearly, as I move my glasses, that's a White Claw emblem, which would indicate alcohol. The second photograph is a case of Miller Lite beer as well. Can't tell whether it was opened or not. It doesn't appear to me, but I'm not sure. The allegation from father is that mother violated the terms and conditions of the judgment of divorce with possession of alcohol while the children are present. And the order, the judgment, indicates that neither party shall consume any controlled substance except as prescribed, nor shall either party consume alcohol 8 hours prior to it during any custodial time. There's been nothing presented on the record to indicate that consumption had been done. Clearly possession, but that's not prohibited by the judgment of divorce. As a result, the defendant has failed to sustain his burden in this case, and the show cause is respectfully dismissed and denied. That'll be all. Thank you, everyone.
Now we got one more.
Oh, I missed one?
Yeah, for
There's two more.
judgment of divorce issue.
Okay, what's the second issue then? I apologize.
There's also, the issue of the school year parenting time.
Oh, yes, I forgot
And
about
then
that.
Mr. Pomeranke has a property.
Okay, I completely forgot about that.
The father thought he had caught the mother violating a court order after finding TikTok photos showing alcohol around the children. But the judge quickly pointed out a key issue: the order banned drinking during parenting time, not simply possessing alcohol. Since there was no proof anyone was actually drinking, the judge dismissed the claim. What do you think? Fair ruling or missed warning sign? Comment below and subscribe for more courtroom drama.
Let's talk about the custodial time. And I believe what Mr. Pomeranke was looking at was a modification of that to keep the days contiguous with the overnight, correct?
Yes. Yes.
Okay. And what is it that you're proposing, sir?
Getting rid of the Wednesday overnight, adding it to my weekend time. So instead of going back Monday after school, they go back Tuesday after school. The least interruption for the kids. We're doing that now. It's enjoyable. It's not, they don't have to go back Monday, pack up, come back to my house on Wednesday. It's just smooth flow, and it hasn't been an issue.
So you wanted to put it at the tail end?
Yes, but on tail end, I had conversations with Ms. Allison on app posts, sent them to Mrs. Schultz. She agreed. Didn't matter if we put it at the beginning or end. I said, okay, I choose the ending. This way it just flows. No big deal. They just stayed in my house one more night. And she said, no, you're not going to do that because that's not what I chose. I got told no. It's on app posts. And asked Ms. Schultz. She told me no, and she told me yes. Because that's not what she wanted.
Okay. This is your response.
I'm sorry, I was just reacting that I don't speak that way, but anyway. So I was a bit caught off guard by this. I didn't realize that we had any issue as we've been doing it. The kids have been going Thursday to Tuesday for 3.5 months now or whatever. Mr. Pomeranke and I began talking about this back in the beginning of the school year. We both absolutely agreed that the children do not like to come home Monday and go back on Wednesday. It's kind of an upset for them, and they have enjoyed it. So immediately, I just said, we'll figure it out. And so he said, I would like to do it Thursday to Tuesday. And I said, well, I would like to do it Wednesday to Monday if possible. It doesn't really matter if they go a day earlier or stay a day later, in my opinion. So I just asked him if we could, and he said no. He's the one who said nope, Thursday, Tuesday only. So I said, can we try it both ways? I think they have posts, well, some of the have posts attached because the whole conversation isn't in there, but multiple times.
Statements between the parties, if you come up with an agreement on your own, unless it's court ordered, the court can't honor it. I mean, you can agree to whatever you want to agree to, but that if it doesn't follow the court order, then the court order still trumps. So I guess my simple question for you is, do you have any problem with doing it at the tail end rather than the front end?
No, I don't. And that's why I'm just explaining the whole thing, because the other accusations in this motion was that I'm, causing problems or whatever. I mean, you could.
Well, I'm trying to cut through the chat.
Yep, go ahead.
So all I'm asking is, father wants to do it Thursday to Tuesday. Right?
Yes.
Do you have any problem with that?
No, but I would like it noted that I was trying to do a compromise.
Again, I'm cutting through that. Remember the whiteboard story?
Yep.
Clean
I would
slate?
just like it noted that I tried to compromise, and he said no. So yes, I will give him his way. It's perfectly fine that we do Thursday.
Well, it's not a matter of giving it, just a moment, guys. It's not a matter of giving him his way. It's what's in the best interest of the children. Because you told me as well that it appears that the children like this way, doing it doing it that way rather than plucking them out one night during the week, right?
Right.
Let's
They would
just go
just,
with
they
that.
would just as well.
Let's just go with that. Best interest, I agree with it.
And it would also be in the best interest of the children to do Wednesday to Monday. It's no different whether it's the beginning or the end of it. That's the point.
Right,
And
but,
I'm just making note because it's been a continuing thing that I was
okay, well,
reasonably trying to
Ms.
compromise.
Allison, I'm going to interrupt. You stated that you felt you had no problem. I don't care about the communication between the two because I know how bad the communication has
I
been.
know, and that's the
But,
point I'm making.
excuse me, please. You find acceptable the Thursday to Tuesday, right?
I do.
That's what everyone agrees to. Let's just go with that.
Okay.
Court finds it's in the best interest, and we will modify the order to reflect that effective. Oh,
Just for clarification, if the court can confirm whose weekend is currently with the kids, so we can put a baseline order.
That's right. Or it's spring break, so she gets spring break this year.
Who had last week?
I did.
okay, got that.
Yeah, it is my regular weekend, regardless of street.
Okay, what about the property issue, sir?
She was supposed to take care of the home window loan and did not.
That's right, that's the old motion.
Oh, it's been over a year and it hasn't been paid on in over 3. I was the last one to make a payment when I lived in the home. Before I got incarcerated. She did not make a payment since. Everything, I sent all the payments. Last payment was September 2nd, 21, which was, 2 months before I went to jail. I paid it and it hasn't been paid since. She agreed to it in court, saying that she would take all debts held liable with the home, and she would happily take it. That's exactly what said. And had not done anything to take it out of my name. I called foundation. I can't physically do it. They won't let me do it unless she acquires her own financial loan or financial term, whatever, to take the loan over, to pay the loan off. Now they won't accept that because it's past it. They closed it. It's not closed, but.
Remind me, was that in your name originally or was it both names?
Both.
What page, because I do recall that, but what page on the judgment of
It's,
divorce is that reflected?
I printed off a copy. I think it should be with it of the order. I have it here. The I printed off the order that states that I'm supposed to be held indemnified and harmless from the home loan.
Well, we don't have the page number on that. That was my fault.
I don't have it on this either. There's a highlighted area in the middle. Straight line.
Good page from the end.
This hearing took a wild turn. What started as a custody schedule discussion quickly exploded into a fight over parenting, cooperation, and an unpaid loan. The father wanted the kids to stay with him from Thursday to Tuesday to avoid constant back and forth, and even though the mother pushed back on some details, she ultimately agreed. But then came the twist. The father accused her of leaving his name attached to a home loan for years despite a court agreement. The judge wasn't interested in the drama and focused on one question: what's best for the kids? The schedule was changed, but the financial battle was far from over. What do you think? Did the judge make the right call? Comment below, like, and subscribe for more courtroom showdowns.
Apologize for the delay, it's a lengthy file. Foundation Finance, right?
Yes, sir.
Got it. Okay. Ms. Howison, what's the status of that loan?
9/2/21 was Dave's one and only payment on this loan that he was previously ordered by this court to be responsible for in our original judgment of divorce on August 13th, 2021 until the second judgment of divorce entered on July 18th of 2023 for 2 years.
Well, that order was
No
vacated.
payments were made by
Excuse me,
him.
miss, that was vacated. The judgment of divorce indicates there's also another encumbrance on the home, specifically a window loan from Foundation Finance with an outstanding balance of $11,956. Plaintiff states the parties are currently behind in payments based upon correspondence received in July 2022. Clearly, the debt owing on the marital home exceeds the value of the home. Based upon the evidence presented, it is hereby further ordered that plaintiff shall be and hereby is awarded the marital home subject to the underlying mortgage and window loan, and shall hold harmless and indemnify the defendant from both mortgage and window loan. It's your loan.
Correct. Following our most recent judgment of divorce on July 18th, 2023, it was deemed my debt and I called them to handle it. There's no way to take his name off of the loan. They don't do in-house refinancing. This loan has gone to collections and was charged off, which I was trying to just make a point during the time that it was Mr. Randy's responsibility. The only option to get his name off it is to pay it in full. There's no way to bring the loan current since he let it go to collections, and it stays that way until the payment is paid in full. So paying on it now brings the balance down, but it still shows a negative on both of our creditors' reports until paid off. So I am paying on the loan. I'm willing to continue paying on the loan moving forward. I do not have access to $12,000 right now to pay it off in full to be able to remove his name off. I don't know.
What have you been making on payments?
I just resumed making payments now.
When? Just now?
Yes.
Well, hold on, I'm still asking questions here. So this order was entered on July 18, 2023,
Yes.
and you're telling the court that you've not made a payment until 2025?
No.
You were not saying that, or you are saying that?
I am saying that.
Why was there payments made after the order was judgment was entered?
With all due respect, Your Honor, the lengthy divorce and all of the things that have gone about all of this have been a financial hardship on me.
Well, I couldn't imagine. I agree.
Yeah. So again, I reached out to them immediately, and there's nothing that I could do in making those payments right away brings it current or fixes the problem that was already there. So I just put that on the back burner so I could handle other financial responsibilities at this time.
Such as what?
Such as what?
Yeah, what other obligations?
Oh, paying off the legal fees and supporting my children.
Okay, well, there's nothing in the judgment regarding paying legal fees first, right? I mean, it's court ordered in this thing, that you're supposed to pay this mortgage.
Well, but what's his legal fees? Ms. Hovecki was threatening to take me back to court if I didn't get that paid to her. I mean, it's coming at me from every angle. But regardless, Your Honor, I apologize.
Well, it's not a matter of apology, it's just a matter of simply following the court order.
And I will make the payments moving forward. That's all I can do.
What are you requesting, sir?
I would like it paid in full. It's ruining my credit. It's on my credit.
Sounds like it's ruining her credit.
It should have been paid. She said, it says right here, the plaintiff will be happy to take over the loan. She says she wanted it. If not, sell the home and then pay off the windows. Sell the house. I'm trying to move forward with my significant other and my family, and I need to buy a bigger home. And I can't do that because I can't get a loan for my credit. and I got hardships too. I got.
This hearing took a shocking turn. What started as a custody case quickly became a battle over a $12,000 unpaid loan. The father claimed the debt was ruining his credit and preventing him from buying a new home. The mother admitted she hadn't made payments for nearly 2 years, blaming financial hardship and legal expenses. The judge wasn't buying the excuses, reminding everyone that a court order must be followed. As the tension grew, both sides pointed fingers while the judge demanded accountability. Comment below, and don't forget to like and subscribe The Legal Lens for more courtroom drama.
I have a house note and legal fees. I'm not complaining. I'm not crying. Everyone has issues. But I'm trying to take care of my stuff legally. And this is the legal way to do it. I can't force her to pay $12,000, but I need my name on the loan in order to move forward with my life.
What is it going to take to get this out of collection?
There's no way to get it out of collection other than to pay in full. And they don't do in-house refinancing, so they told me I would have to get a personal loan or some other
I
way,
agree.
which I've already
Sure.
taken out personal loans and credit cards.
It's got to be paid.
Yep.
I recently spoke with Foundation 2 months ago, and there was no payment up to then.
Well, she admits, she just started
It's
paying.
not about the payments, that doesn't.
It comes down to the obligation.
Yep.
It's got to be paid. That's part of the court order.
Also, Your Honor, the house is supposed to be on my name as well, but I can file another motion, sorry. I'm not trying to cut you off, I was just,
So you did, but
If you want-
I've been cutting everyone else.
We're here.
No one's listening to my question.
sorry.
Don't be sorry. You're fine. What are you going to do regarding payments? Is there some sort of settlement that they would agree to? How is it?
No, because it was charged off. They don't have the ability to do anything because he allowed it to go to collections.
Well,
That was why I was making a note of that. I know it's passed.
so are you talking with the collection agency?
No, I only talked directly with Foundation Finance.
But they discharged her, correct?
I mean, they still.
They handed it off to us,
They're still accepting payments.
but it went to collection.
Yes, it's in collections. It's been in collections since February 28th of 2022.
What can you make in the form of payments?
I'm paying $150 a month already. But that doesn't get it paid off very quickly. I understand that, Your Honor. I mean, if I can be given a length of time at least to deal with it, I don't know.
How much time are you requesting?
$12,000 is a lot of money.
I know it is, believe me.
Is there a reasonable standard for this? I don't know.
About 6 months.
Yes.
Any objection to that?
No.
6 months. We'll schedule a date now. If it is paid off and proof is provided, we won't need to have a hearing. If it is not paid off, parties need to appear. We have a date. And I'm sorry, I'm severely enforcing the judgment.
I understand, Your Honor.
Your Honor, you want me to file a motion for the home loan as well? Because she hasn't done the home loan out of my name either. Or should I file a motion and come back?
I can't tell you what, you can file whatever
I'll
motion
file a
you think
motion
are
and
appropriate.
we'll take care of it another day.
September 26th.
Can the parties be available September 26th?
Yes.
Yes.
Great. 9 a.m.
9 a.m.
9 a.m. it is.
I'm gonna give them that.
We're gonna give you notice now. And hopefully by that time, we can have some, hopefully resolution on that issue. I'm glad that you're both looking at the best interest of the children regarding making these dates consistent with each other, contiguous, I should say, connected. And,
The courtroom tension wasn't over yet. The father told the judge he wasn't looking for sympathy, he just wanted his name removed from a debt that was hurting his credit and holding back his future. The mother admitted the loan had gone to collections and said she could only afford $150 a month. The judge made it clear that the court order had to be followed and pushed both sides toward a solution. In the end, he gave them 6 months to resolve the issue and scheduled another hearing to check their progress. At least on one thing, both parents agreed, putting the children first. What do you think? Was 6 months fair, or should the judge have taken stronger action? Comment below, and don't forget to like and subscribe The Legal Lens for more courtroom drama.